$93.9 trillion. To put that into perspective, that is roughly equivalent to the entire global GDP. Now, what if I told you that this staggering number isn't some national debt figure or a wild economic forecast, but an actual invoice? A literal, formal commercial invoice sent directly to the United States Securities and Exchange Commission and a federal judge. Okay, let's dive into this.
Welcome to The Explainer. Today, we're unpacking what has to be one of the most complex, unconventional, and frankly, mind-boggling legal rebuttals out there. We're breaking down an official 2026 response document filed by the NVC Fund Holding Trust, authored by its general executor. This document is essentially a massive counterstrike against the SEC after a years-long legal battle. It's a fascinating study in conflicting legal realities, and today, we're strictly looking at exactly what the trust asserts in this incredibly dense filing. Here's our roadmap for today. 1. Jurisdiction and entities. 2. Rebutting the allegations. 3. Procedural flaws. 4. 3 waves of interference. And finally, number 5. The trillion-dollar counterstrike. Let's start with Section 1. Jurisdiction and entity distinction. The trust's entire defense really hinges on a vital distinction between two separate entities. First, you have the parent entity, the NVC Fund Holding Trust, which was established back in 2000. Then you have NVC Fund, LLC, which is a private Delaware subsidiary, established 9 years later in 2009. The SEC's enforcement action explicitly targeted the LLC. But, according to the document, the SEC then took those findings and wrongly applied them to the parent trust, without ever formally piercing the corporate veil in a court of law. The trust argues this is a massive violation of standard corporate law.
So, what is the parent entity? Well, it classifies itself as a common law pure trust. In plain English, they claim they answer directly to the U.S. Constitution and natural law, not to state laws or federal regulatory agencies. Because the SEC is a statutory creation, created by Congress to regulate statutory entities, the document argues the SEC has absolutely zero jurisdiction over this parent trust, literally none.
Moving on to Section 2, Rebutting SEC Fraud Allegations.
So the SEC originally alleged a pump-and-dump scheme involving third-party companies, but the trust's rebuttal is highly specific and pushes back hard. First off, they assert NVC Fund LLC was merely an asset provider that was lending preferred shares. They say the borrowing companies wrote and issued their own press releases. The LLC didn't author a single word of them. Second, when the SEC claimed the trust ignored subpoenas, the trust fires back saying, actually no, they were raising a legitimate jurisdictional objection, not hiding evidence. And finally, regarding those massive asset valuations the SEC questioned, the trust argues they aren't pulling numbers out of thin air. They simply rely on standard institutional metrics applied to international development assets.
And to prove they aren't just fabricating numbers, the trust points to this specific figure, $48,881. According to the filing, this is the appraised value of a single trust certificate unit. The trust emphasizes that this valuation wasn't a guess. It was verified in 2017 by an independent CPA firm using internationally recognized standards, and this very appraisal was even filed in federal court. The kicker here? The document argues the SEC had this appraisal right in their hands, but willfully chose to ignore it.
Section 3. Procedural flaws and default.
Now, this is presented as a major gotcha moment in the trust's rebuttal. This is a verbatim admission from the SEC's own motion for default judgment filed in March 2021. The agency openly stated it had no claim or allegations regarding damages. The trust's document leans heavily into this. They argue that under the specific securities law being invoked, Rule 10b-5, actual economic loss and an injured party are absolutely mandatory requirements. Essentially, the trust is pointing out that the SEC publicly prosecuted a massive fraud case while privately admitting on paper that they didn't actually have a victim.
So if they didn't have a victim, how did the SEC win? The trust outlines a very specific sequence of procedural events. First, the SEC secured a default judgment against the LLC simply because a responsive pleading wasn't filed on time, not because evidence was actually proven in court. Then, the SEC settled with the one and only defendant who actually hired a lawyer. Following that, all the trial dates were completely vacated. And finally, a new judge stepped in and granted civil penalties against the defaulting parties without any substantive adjudication of the facts. The trust's whole point here is that no actual fraud was ever proven on its legal merits.
That brings us to Section 4, 3 waves of interference.
The document outlines what it claims is an 11-year history of targeted institutional disruption. First, in 2010, they claim SEC interference totally destroyed a massive bond offering with PA Foundation. Then, in 2013, they alleged the SEC falsely investigated their banking partner, which ended up ignoring a staggering $50 billion deposit the trust had made. And finally, in 2018, they claim the SEC actively intercepted $700 million in preferred share investments. The trust views all of this not as standard everyday regulation, but as a systematic financial vendetta aimed at destroying their market access, ruining their reputation, only to later close the cases without ever proving fraud.
And finally, Section 5, the trillion-dollar counterstrike. So the trust didn't just write an angry letter. They filed severe, formal counterclaims against individual SEC officers. We're talking serious allegations here. RICO Act violations, alleging a corrupt pattern of racketeering across those three ways of interference we just talked about. They also allege deprivation of civil rights under color of law, arguing the SEC systematically targeted a minority-owned institution's access to capital markets. And you can add claims of defamation, slander, and intentional interference with commerce to that list too.
Which brings us right back to that unbelievable $93.9 trillion number we saw at the very beginning. How on earth did the trust calculate it? Well, the document breaks down the math behind the commercial invoice sent to the federal judge. They took the capital that the SEC allegedly prevented them from deploying during those three waves, and they applied historical year-by-year S&P 500 index returns to it. So Wave 1 resulted in $47.7 billion in lost returns. Wave 2, $181.1 billion. And Wave 3, based on their massive claimed asset base, accounts for an absolutely mind-numbing $44.7 trillion in lost returns. When you add it all up and project it forward, that is exactly how they reach that ultimate invoice.
The sheer scale of this conflict is almost hard to process. Just think about the contrast here. You have the total civil penalties actually levied by the SEC against the LLC and the executor, which is a little over $1.1 million. Then you have the trust's supposedly pragmatic settlement offer to the SEC, sitting at roughly $4.8 trillion. And then the total calculated invoice for lost returns stands at nearly $94 trillion. The trust uses this massive, almost comical disparity to argue that the SEC's comparatively tiny penalties prove the agency never truly believed they were fighting a multi-trillion-dollar fraud.
Ultimately, the document wraps up with a very firm declaration of ongoing legitimacy. The trust asserts that despite whatever domestic injunctions might exist against its private Delaware subsidiary, the parent trust is alive, well, and doing business. They claim their institutional banking operations remain fully active, operating entirely legally under international African Union treaty frameworks and completely unbothered by U.S. statutory rulings.
It is an incredible standoff. On one side, you've got a U.S. federal regulatory agency relying on statutory law and default judgments. On the other side, a self-declared common law pure trust asserting supreme sovereignty, citing constitutional rights, and demanding literal trillions in compensation. It leaves us with a profound question to think about. When conflicting legal realities, statutory regulation versus claimed sovereign rights, collide on a multi-trillion-dollar scale like this, who ultimately gets to decide the truth? Thanks for joining me on this explainer. We'll see you next time.